Good morning. My name is Lauren Hoff, and this panel is entitled Working Outside the Lines, Immigrants and Exclusions from Labor and Employment Protections. Before we get started, I just want to make a quick note for those of you that came in late. The Journal of Law and Social Change, Penn's Social Justice Journal, has free copies of their concurrent symposium issue available at the registration table. So everyone, please feel free to take a copy. And if you're interested in staying in touch with the journal or submitting work, there's an insert inside that you can fill out and return at the registration table. Immigrant workers, both documented and undocumented, are often excluded from labor and employment protections due to their immigration status or because of the industry in which they work. For example, minimum wage and overtime requirements often do not apply to industries dominated by immigrant workers, such as agriculture and domestic work. Workers in these industries also do not have the right to organize. Even where workers do have the right to organize, undocumented workers cannot seek relief knowing that their employers can retaliate against them. Additionally, immigrant workers often face barriers in accessing the employment and labor protections that they do have. For example, immigrants who come to the U.S. on guest worker visas can only work for the employer who sponsored them and may fear retaliation if they assert claims against their employer. Furthermore, organizations that receive Federal Legal Services Corporation funding are generally barred from representing undocumented immigrants, as well as some immigrants in the country on temporary work visas. These examples are by no means an exhaustive list of the legal protections immigrant workers lack or the barriers they face, and today we will only address a subset of these issues. We will focus on different strategies attorneys and workers' advocates use to navigate these legal and practical barriers, from legal services and litigation to grassroots organizing and legislative advocacy. Joining this conversation are 4 panelists with experience using these different strategies to assist a range of different immigrant workers. Art Reed has advocated for workers throughout his entire career. For the past 30 years, he has served as the general counsel for Friends of Farmworkers, a Philadelphia-based organization that advocates for and litigates on behalf of undocumented and documented low-wage immigrant workers in Pennsylvania. Cathleen Caron has over 15 years of human rights experience in the United States and abroad. She is the founder and executive director of Global Workers Justice Alliance, an organization that aims to better connect immigrant workers to legal remedies for employment violations after they return to their home countries. Anna Avendano is the assistant to the president and director of immigration and community action at the AFL-CIO, where she oversees efforts to broaden the labor movement through labor community partnerships and by connecting to immigrant communities. She also advises national and local union leaders on domestic and international immigration policy and other matters that impact immigrant workers. Lorelei Salas is the legal director for Make the Road New York, a community-based organization that offers a full range of legal services that support Make the Road's broader organizing and policy campaigns. Prior to her work at Make the Road, Ms. Salas worked in the New York State Department of Labor for over 10 years. We hope to have time for audience questions at the end of the conversation, and so if you think of a question for the panelists at any point in the conversation, please write down your question on the note card found on your tables, raise your hand, and an event staff will come and collect your card. Now to start off the conversation, Mr. Reed. Friends of Farmworkers provides legal assistance to low-wage immigrant and migrant workers throughout the state of Pennsylvania and has been involved in national litigation and advocacy in relationship to agricultural and non-agricultural temporary guest worker programs. Please briefly explain these programs, a common legal problem these workers face, and your role in advocating for these workers, as well as some challenges and successes that you've had in this advocacy work.
I have 5 minutes, and I started an on-screen timer to keep me on track. So, it's great to be here. When I went to law school, I don't think we used the 1L, 2L, 3L term, but I figured out the other day I'm now a 39L. I think in talking about the guest worker programs, it's important first to step back and talk about the distortions to the labor markets that have been caused by immigration laws generally. And in particular, this degree to which undocumented, oh, I'm supposed to have a little microphone, okay? The degree to which undocumented workers have already resulted in a depression of wage rates throughout the country. Now it's on. When we talk about guest worker programs, and I don't really like that term, but let's go ahead and use it because it's what's get used in common parlance. The piece that's really important to realize is that employers are bringing those workers into labor markets that have already been depressed by employer exploitation of undocumented workers. And in particular, in the last 12 years, the approach of particularly the Bush administration was that guest worker programs should be able to economically compete with undocumented workers, and that it should be cheaper to bring in a guest worker than it should be to use an undocumented worker. That was part of the economic functional premise behind how they administered those programs in the Bush administration era and how they promoted those programs. It was the employer take on these programs is, why should I have to pay a worker from another country a total cost to me, including my cost for bringing workers into the country, that is more than I would have to pay an undocumented worker. In Pennsylvania, one of the issues that we struggled with, and you talked about workers who had no protected rights to organize, was organizing of mushroom workers. Half the mushrooms in the country are produced in Pennsylvania. In 1993, there was a strike at a company in Kennett Square that's one of the largest producers that ultimately led to the certification of a union there. And in the late 1990s, as that process was going on, the mushroom industry in Pennsylvania filed applications to bring in 1,500 H2A temporary agricultural workers into the mushroom industry. And we looked at what did that mean objectively for the organizing rights of workers in that industry, and it objectively meant a depression of wage rates. Because the rates at which workers would be allowed to enter the country would forbid, as a practical matter, the right of workers who were already here to fight for, collectively, better terms and conditions of employment. They would reduce existing systems of incentive piecework systems. That's what made many of those jobs attractive to workers who were in those jobs, many of whom were documented. So that the whole question of the relationship between temporary workers and the right of workers to act collectively and to present grievances and to pursue those grievances and to be free from retaliation is really fundamental to understanding the guest worker programs. The other thing that's really important to realize is the importance of what I would call the diversified workplace. You do not want an industry that becomes captive to a temporary worker program because it essentially eliminates any incentive to those employers to comply with the law. Why? Because if you have a totally guest worker driven workforce, you have the complete ability to threaten to retaliate against those people, to threaten to reemploy them, and more importantly, in the reality of how those programs work, it's not just the individual, it's the communities from which they come. The very first temporary H2B, non-agricultural workers who came to us in Pennsylvania, said that my uncle is the recruiter, and my whole village will lose its jobs if I go ahead and make a complaint about what's happened to me. My family has told me that I cannot make a complaint. That was the circumstances in which we had to go forward. That's the circumstances in which we have to struggle. I'll have to probably save, given the time period, some real discussion to questions if people want to know more about the specifics of how those programs work. But I think the fundamental issue to understand is that the existing programs of guest workers are programs which create an exploitable workforce. And if immigration law reform doesn't change that, doesn't continue to make people captive to employers in ways that they're exploitable, that immigration reform will result in a depression of wages of U.S. workers.
Thank you, Mr. Reed. I was wondering, Ms. Caron, if you could jump in here and just explain a little bit more about some other temporary worker programs and some problems in these programs as well.
Sure. So when I started, I will, in another question, I'll talk a little bit about the work we do. But when I started the work, I thought the universe was the H2 visa, which is a temporary low-wage worker visa for less than 1 year, and you're tied to the employer that sponsors you. So pretty much coming out of the farm worker world, these were the first visas we started seeing was H2A visa, which is the farm worker visa. But then we started seeing manipulation and moving around the system a bit, jumping to different visas. As one visa got more regulated, employers were gaming the system with good immigration attorneys on their side to figure out which different visas they could use to get the product they still wanted, which was a worker, but underneath a visa that was easier to with less regulation and less protections. So this led to a lot of concern that there was workers coming up saying, I'm on a J1 visa, I'm on a different type of visa, and the employment law lawyers had no idea what these visas were. And also with the work I do, we do a lot with consular officers overseas, and they were also talking to me saying, Kathleen, I'm really concerned because we're handing out these visas that seem completely inappropriate for the jobs they're going for, but we're not, with the structure of the temporary worker programs, the consular officers, the decision's made by the time it comes to the consular officer. They can't, they're not approving the employer to participate in the system. So what we did was we ended up writing a report, and I left some reports out there called Visas, Inc., to try to take a really broad view of what is the temporary guest worker program. I tend to call it foreign temporary worker programs because that's the global terminology more, because this is very much a global trend to have workers come on temporary visas and not stay. So they're not allowed a pathway to citizenship. They just have to work for that employer for a particular period of time and leave. And so in that report, what we tried to do is just understand the system, because there's so many different visas. So we looked at 9 different visas. And so there's the formal work visas, which are the H visas, where the Department of Labor has a clear role. So the Department of Labor, the first part is to make sure that US workers are not displaced. And so they have wage protections, they analyze the wages to set it at a certain level so that US workers, you don't just depress wages. As Art said, there's problems with the system, but at least there's an effort and a political decision to try to protect US workers. The problem is all sorts of other visas that they work on the visas, but the Department of Labor has absolutely no role in them. And so some of these visas are J1 visas, and there's probably people in the room right now who are J1 scholars at UPenn. I'm sure there is right now. The thing is, there's other people that come in, au pairs, camp counselors, summer work travel trainees, and they're working, and there's incentives to hire them over US workers because you don't have to pay payroll tax. So some of these visas really work it in, so it's cheaper to have a foreign worker. And you don't have to look for US workers at all. They don't even get to apply for the job. It doesn't have to be advertised. So the point being, there's lots of different visas out there, and it's a pretty confusing system. And I will stop it there.
Great, thank you very much, Ms. Caron. Ms. Salas, I was wondering if you could talk about Make the Roads Legal Services and how your program is a little bit unique and how it supports your organizing mission.
Sure. After seeing how quickly 3 minutes go by, I just want to focus on a couple of things that are kind of important to understand, is that New York State actually has pretty protective laws of all workers. Maybe there's still a couple of groups that are excluded from them, but domestic workers are not protected under New York State law. So the issue is not, yes. The issue is not whether there are laws that are protecting workers, whether they're undocumented or people who have legal status to work, is whether enforcement is sufficient there to guarantee that these protections actually, protections that are in the books are really a reality for workers, right? And Make the Road is a base building organization. We have over 12,000 members who are mostly Latino immigrants, and they pay a lifetime fee of, it's just $100, but it's still a little investment of money, and are active participants of the organization. And it's those members that come to us, to the lawyers in the organization, to tell us what it is that they think the fixes should be to the law. For instance, in 2010, Make the Road Work drafted and passed in record time the Wage Theft Prevention Act. I think there are copies of that, like a little package of that on your tables. But it's a law that made retaliation laws, the protections against retaliation, a lot more aggressive in New York State. So one of the things that was coming out at the meetings that members hold in our offices in the evenings, where they discuss the problems they're facing, is that the retaliation law that was in the books in New York was not enough to protect them. Like if they went to their employer to ask for overtime wages that they were owed, it wasn't the boss who actually fired them or told them, well, from now on, since you're asking for overtime wages, I'm gonna cut your hours to half. It was the wife, it was the cousin, it was someone else connected to the employer. But when you read the law itself, that was not conduct that was protected, right? So what we did was, instead of saying, sorry, there's nothing we can do here, we went to the table, drafted a law that makes this conduct protected. So now, if an employer retaliates against an employee through their cousin or their wife or their spouse, there are severe penalties that are associated with that. And workers, since they don't have a right to reinstatement if they're undocumented, the workers get to have $10,000 in liquidated damages for each retaliatory act of the employer. So this is how we operate. We recognize that the law on the books is not enough, oftentimes, and there's a lot of organizing going on by our own members. So in cases in which there's nothing that we can do legally, you will see our members going out there in front of a business and just holding a press conference and denouncing the violations of the employers, or writing letters in support of someone who was retaliated against and fired because, let's say, they were sick one day and couldn't come to work, and the employer simply said, well, you don't have a right to a sick day. I don't need you anymore. And so they will go out there and write a letter and say, please give this person their jobs back. We don't want someone sick coming to work here and contaminating others. But it's like the power of the collective, voice of the workers that really helps a lot. And my time is up. So.
Thank you, Ms. Salas. And Ms. Caron, if we could go back to you for a moment, I was hoping you could expand more and talk about your experience representing farm workers and what led you in that experience to found Global Workers Justice Alliance.
Sure. So right out of,
That doesn't count for her time.
right. Give me 10 seconds. So right out of law school, I had a EJW fellowship. It wasn't called that back then, but I went down to Florida and I was representing farm workers in employment law cases, run-of-the-mill minimum wage cases, just never endless amount of minimum wage cases to do in the state of Florida, the farm workers. But what happens is that migrants don't always stay. Migrants don't necessarily come to the United States assuming they're going to stay here for the rest of their lives. A lot come and they think they're going to stay a couple years, earn a lot of money, and go home, especially with the undocumented population. So what I was finding was litigating these cases on behalf of workers when they were all undocumented, about 10% of my clients left. Made it really, really difficult. So for example, we had a deposition set for Tuesday. It was Thursday. The client called and said, my mom is dying. I'm going back to Guatemala tomorrow. And I said, can you just wait 2 days because your deposition is scheduled and we're going to win you $3,000, which of course her priorities are mother. She's going to go home. So I dropped the case. So that there was others examples where they actually flew me down at the time because I had clients in Guatemala. I would do depositions down there and come back. But the real case that did it for me was this huge case we had against major pine tree growing companies with Georgia Pacific International Paper and Champion, this massive case trying to go against H2B visas and the various abuses that happen, wage abuses that happen on it. So there was probably, these numbers aren't going to be right, but let's say there was about 2,000 Mexican available clients. There was about 600 Guatemalans that could participate, and there were about 100 Hondurans. So when you're a small NGO based in the United States with limited resources, you're looking at this massive case, and they had to do interrogatories. So the Mexicans, there was enough concentration of Mexican workers that they said, okay, we'll definitely do the Mexican workers. The Guatemalans, they weren't going to do, except I happened to show up, and I'd lived in Guatemala for almost 4 years, and I had experience in Guatemala, so they said, well, Cathleen, would you do the Guatemalan workers? And I said, well, sure, I'd love to go down there. But then the Honduran workers were out because no one had experience in Honduras. So kind of as I started working on that litigation, I just started naturally going to organizations in Guatemala saying, this is what we're doing. This is a transnational issue, and we're handling it very unilaterally, really, because it's just the US, what we were doing was just going down, signing up the clients, doing the casework, and then flying back to the United States, and that was it. So I founded the organization in 2005 to work on portable justice. So how can migrants have the ability and capacity to access justice in the country of employment, although they're no longer physically present? Because workers go back, especially with the temporary guest worker programs. The visas say go home. That's the design of the project. So if we let these workers get cut off from justice because they go back to their home countries, we're really giving a green light employers to say these workers are even more vulnerable, more exploitable, and then just send them home and silence them. So the point of the work that we do is we're working from Mexico, US and Canada as countries of employment, and then Mexico, Guatemala, El Salvador, Honduras, Nicaragua, the whole region. We've said the core of the work is really a defender network. So we've identified human rights organizations that already exist in the field. There's lots of great organizations all over the world embedded in communities that are sending communities of migrants who have a lot of talent and they're very interested in this issue, but they don't have access to US laws. They have no idea how to counsel someone on the Wage Protection Act in New York State to know what their rights, because the wife of the employer threatened them that they actually get $10,000 for that. I mean, how is an attorney in Huehuetenango, Guatemala absolutely going to know that issue? So they're not going to. So what we've done, but there's plenty of people that are smart and want to work on this issue. So we've teamed them up. We have 40 organizations, almost 40 organizations working with us. We train them on US labor law, and then they work on cases of individually exploited workers. So we team them up with US organizations in the casework, and they kind of do on-the-ground paralegal support work they need to keep that worker in the case. We also do education programs, so pre-departure programs, so workers have some sense of idea of their rights before they come to the United States. I can't tell you how many really good human rights lawyers I've met south of the border that say undocumented workers don't have labor rights. That's right? So, if there's one thing I can change is that people know that undocumented workers have rights, because they come up with a mentality, right? And where can we change that before they come? Big opportunities. And then we also do quite a bit of advocacy work. We do a lot about the laws that are on the books for protecting migrant workers when they're recruited through temporary guest worker programs. A lot of these countries actually have national laws to protect them for a foreign company recruiting to take them abroad. So we've issued reports. We're doing quite a bit of advocacy in Mexico around the enforcement of their equivalent law, which is Article 28, and through the region. So let's see, I think I condensed it so much, but I think that time's up anyway. There we go. So that's what we do.
Thank you, Ms. Caron. Ms. Avendano, shifting now from legal strategies to organizing strategies, union membership has dropped across the country, but has grown geographically where immigrants are overrepresented. Can you talk about the legal and practical exclusions immigrant workers face in organizing?
Sure. I'm going to answer the question, but I want to just step back for one quick second and sort of root this conversation historically. The concept of work authorization, something that everyone here has alluded to, is a fairly new, young concept in our jurisprudence. Until 1986, there was no such thing as having to prove that you're authorized to work in the United States. The IRCA that Lucas talked about earlier required that. For the first time, workers have to prove to the employer that they are who they say they are and that they are authorized to work in the United States. The idea behind the law was that at the time, to stop unlawful migration would be to cut off the best way to address irregular migration, illegal immigration, whatever term you want to use, would be to cut off the job magnet. And if workers had to prove they were authorized, they wouldn't be able to work, then they would go home. And that law has been a disaster. It didn't work. It wasn't really actually designed to work because of the compromises that had to be made politically to get the legislative language. But in practicality, what it's done is that it has actually turned employers into agents of the Immigration Service. So now, I mean, all of you, the students here, young people in the room, the concept of having to fill out a form to show your passport or your green card or some document that shows you're authorized to work is second nature to you. But really, that hasn't always been the case. What the IRCA has done is really given employers one of the best union-busting tools that they've ever had. Because now when workers try to organize, when they make any sort of worksite complaint, whether it's about wages, sexual harassment, injury, or anything like that, the first question that employers often ask is, well, Anna, your papers don't look so good to me now. Can you bring in a fresh set of papers? And that just kills workers' ability to enforce their rights. So the biggest impediment, actually, to workers being able to enforce their rights has been this very badly constructed concept of worksite authorization that unfortunately is here to stay. There isn't any sort of political will or anything to change the system of asking workers to verify their status. So what we're working toward is actually organizing strategies, legal strategies, to actually work around the law right now, and as we go into immigration reform, to fix the law. I'm going to give you a very quick example of what I mean by that. Currently, we're working with the United Steelworkers and a worker center, Voces de la Frontera in Milwaukee, organizing a group of workers at a pizza factory, whose workers were mostly Guatemalan and Mexican workers. Some had been employed at this pizza factory for 10, 15 years and had suffered really abusive conditions at the hands of a supervisor. And by the way, most workers' complaints aren't about wages. There's a conception that workers are only complaining about their own economic interest. Most complaints are about dignity. So the supervisors would actually take photographs of the workers on the shop floor and send them to each other, sort of to laugh at the workers. They would laugh at their accents. They would really just insult and just treat the workers very badly. And so workers started to organize, and they did a petition to the company about this particular supervisor's conduct. They were promised changes, nothing happened. So eventually, working through the worker center, they joined with the steelworkers to actually try to move toward collective bargaining. Now, collective bargaining is particularly important for low-wage immigrant workers because collective bargaining really institutionalizes whatever gains workers make on the ground. And it provides a system for workers to be able to monitor and enforce workplace conditions so that they don't have to rely on government labor inspectors, so that they themselves have a grievance process, a way to remedy the kinds of conditions that I was talking about now. As soon as the employer found out that the steelworkers were involved in this campaign, they immediately pulled out of the drawer a notice of intent to fine from the Immigration Service that was over a year old and asked the workers to re-verify their status. And then the workers refused. The workers actually went on strike, and they've been on strike now for almost a year. The employer technically fired all of them. We filed a complaint with the National Labor Relations Board, and because of the law that a decision that came out in 2003 called Huffman Plastic Compound, I don't have time to get into it right now, but it essentially cut off the ability of workers to get a remedy after having their rights violated. Workers cannot get back pay now. Under a very bad interpretation of that law, the NLRB has determined that the workers were not fired for genuine protected concerted activity, but that the employer had a right to demand that the workers reauthorize their status because they were just following the immigration law. And therefore, the workers now have no protection for their strike. So my time's up, but the point I just want to make is that it's this very perverse system that we have right now that actually encourages violations of law because it really has created an economic incentive for employers to just hire undocumented workers, deny them their rights, and then push them out the door.
Thank you very much. Ms. Salas, I was wondering if you could talk about Make the Roads campaign for car wash workers in New York that focuses on using organizing to address wage theft and expand on strategies in that campaign, as well as some specific challenges in organizing undocumented and low-wage workers generally.
Sure. So the car wash campaign started approximately a year ago, let me think. Yeah, actually about a year ago. It's called the WASH campaign, and it's a project of the New York Communities for Change and Make the Road New York with the support of the Retail Wholesale Department Store Union. There are about 200 car washes in New York City and employing approximately 5,000 workers, most of whom are immigrant workers and a majority of whom are undocumented. Several years ago, back in 2008, 2010, there were a couple of big operations, one by the New York State Department of Labor and one by the US Department of Labor, where the New York State Department of Labor's proactive investigation of the entire industry showed that 80% of the car washes in New York City had violations of minimum wage and overtime wages. So that's a huge percentage of businesses in New York City that were paying workers below what the law requires. Subsequent to that, the US Department of Labor actually litigated a large case against one of the biggest car wash employers that operates nearly 23 or so car washes in New York City, and had them order them to pay, I can't remember exactly now, but close to $2 million. Okay, we're talking 3 years ago, right? 3 years later, Make the Road and New York Communities for Change organizers go out there and talk to hundreds of workers, trying to survey the working conditions at this time. and find out that while the employer on the books appears to have reformed their practices and be paying correctly and under the law, workers are being cheated out of tips. So what happens in New York State, even though the minimum wage is $7.25 an hour, the employers can legally pay tipped employees a reduced minimum wage. In the car wash industry, you can pay someone $5.50 an hour as long as they earn enough tips to make up to the minimum wage. But that rarely happens. Oftentimes, they don't make enough tips per hour to justify that reduced wage. So in the 3 minutes that I have left, what's interesting about this campaign is that we have held 5 elections so far, won 5 elections with a huge majority of workers. We have, the wins were like 20-3, 19-6. So we had like a lot of support from the workers to get a union in place. We have not yet, we're in the middle of contract negotiations, and a lot of the issues about immigration status have come up at different times in different forms, but we have been able to overcome those issues by a number of different strategies. We've filed complaints with the New York State Attorney General's office. We have filed complaints with the National Labor Relations Board. We have held rallies and press conferences with the community, electeds, and clergy would come out and basically support the campaign and ask the employer to stop retaliating against the workers. We've used, the media to send the message out there, and just basically like empowering the workers. Something just beautiful that happened was that we received a call one night from workers at one of the car washes we were organizing, had been contacted by a different group of Bronx in New York, in the Bronx, in the county. There was another car wash where the workers decided to walk out and call these other workers and said, like, what can we do? We left our employer because he hasn't paid us in 3 weeks. So the workers came to the campaign. We weren't looking for them, but they had heard about the changes and how people were fighting for their rights, and they called us. And it was something where we just didn't know what to do with this group of workers that we had never met, but desperately needed help. They went on strike, and they went on strike for like 4 to 6, I can't remember exactly, it was over the holidays last year. I believe 6 weeks, not working, not earning a penny, but they stayed strong. And car wash workers from other locations would come out and support them. The board just issued a decision that the employer basically retaliated against the employees for concerted protective activity and has ordered the employer to pay nearly $40,000 in back pay. But this is kind of like an example of the kinds of things that we are seeking to get, right? We're seeking to get workers to organize and to basically improve their working conditions, because litigation alone is not going to do it, and enforcement agencies are not going to be able to do it either.
Great, thank you, Ms. Salas. In talking about immigrant workers, I was wondering, Mr. Reed, if you could expand on the relationship you see between advocating for immigrant workers and its impact on low-wage workers generally.
I think I only get 3 minutes for this round, so this is going to be even harder. It's very direct, and I think that's just really important to understand. The principal business side advocates for immigration law changes are driven from a belief that immigration is a net economic positive because it drives down wage costs, because it makes people work for less money. And Professor Chang at the law school is actually one of the academic advocates of the position that immigration is something that's positive because we as an economy benefit from the suppressed wages that immigrant workers accept. Fundamentally, the US Congress, unfortunately, accepts the notion that it is a positive for low-wage workers to be low-wage. And I don't know any worker who aspires to be low-wage. That's not your goal in life. I think Anna's point, though, about dignity is really fundamental. Part of what I saw in my work with mushroom workers and agricultural workers in Pennsylvania is spontaneous concerted protected activity was actually incredibly common. In the mushroom industry, the number of quickie sort of work stoppages that workers had over the years were very frequent, and they were driven by foremen treating people unfairly, by a series of things that happen at the workplace that made people say, I've had enough, I can't take it. If we have a system, and that's really what I think some of the debates are going to be about immigration law change, in which we allow employers to have unlimited access to low-paid workers, to replace workers who are trying to fight for a better standard of living, we will undercut the right of all workers to a decent standard of living and the right of all workers to act collectively for better terms and conditions of employment. I think that we've got to change the Hoffman Plastics rule. There are those of us here, and Anna was amongst us, who fought with the Clinton administration in 1996 to get the Department of Labor, to get the NLRB, to get the EEOC to adopt the rules that the Supreme Court overturned in 1983 that specifically recognize that all workers suffer in their rights if undocumented workers can't enforce their rights. No workplace can effectively organize with even a minority of undocumented workers if those workers are subject to threats and exploitation because of their immigration status. We represent organizations that have been involved in grassroots kind of organizing activity with workers. Those organizations have clearly understood and directed us in our advocacy for 25 years that those temporary worker programs, expansions of those temporary worker programs, are destructive to the rights of all workers. Time's up.
Thank you, Mr. Reed. We've heard today primarily about problems in litigating and organizing, as well as strategies, and I'd like to turn to the potential of national legislation to reform our immigration system. Ms. Avendano, the AFL-CIO, has been working closely with the Chamber of Commerce to help negotiate the shape of reform. Can you explain what reforms are being considered and what are some potential compromises?
Sure. So we've been working with the Chamber of Commerce on one very tiny little sliver of the big package that's comprehensive immigration reform, and that's future flow, conditions under which workers will come into the country into the lesser skilled or the low-wage labor market. And it's been a difficult conversation. But I want to make clear the labor movement's top priority is the roadmap to citizenship, or the legalization that was talked about earlier this morning. In our view, without an inclusive, broad, and swift legalization program, basically the whole construct of immigration reform falls apart. If we don't have as many workers as possible included in the legalization program, there are still going to be communities that are affected by secure communities and other programs, immigrant communities around the country feeling terrorized. There will still be the issue of undocumented workers in the workplace to a large degree. And so all of the different pieces of immigration reform are just not going to work unless we have an inclusive path to citizenship. And that means that we can't have conditions in the path to citizenship like requirements that workers prove employment. That doesn't make any sense at the beginning, but it's a really political issue on the Hill right now. It's remnants of the 2007 law that required people not just to prove that they've been here, but that they've been either continuously employed or employed at all. The problem with that is that many of the workers who are going to legalize their status, most, have been either working in the unregulated labor market in the informal economy and aren't going to have the ability to actually ask their employer for a pay stub, which they may not have. They're certainly not going to be able to get an employer to sign an affidavit that they've been employing them unlawfully for more than a decade. So it's those kinds of conditions that are really at the heart and soul from a worker standpoint of what we have to be advocating for. Future flow programs, there's various pieces there in the bill that address future flow. The H-1B visas are part of the mix. We're not actually dealing with those right now. But there are reforms to the H-2B program that Cathleen talked about that we're working on with advocates and with our unions, and those are not the subject of discussion with the Chamber. So I'm going to just focus on what we've been talking about with the Chamber because it's been, the press is obsessed with it. We're really dealing with the lesser skilled, non-seasonal, non-agricultural workers. Now, the way that we've approached this is that we're really talking about workers coming into the country who are poor people who are going to continue to be poor. That's the reality. It's what Art said. The National Employment Law Project, together with some very, very well-known academics, released a report in 2009 that I think everybody should read, and it's on my desk. It's our Bible. It's called Broken Laws and Unprotected Workers. It studied the low-wage labor markets of 3 cities, Los Angeles, Chicago, and New York, the largest 3 cities in America, and looked at the labor and the low-wage labor market and found that there are systemic failures in these labor markets. Employment laws just do not apply, and they are not the one bad apple employer here or one bad apple employer there. They're across sectors, service workers, construction workers, janitorial, you name it, it's part of the low-wage labor market, and that there are intentional employer practices that are causing the situation. The statistic that we find most startling, and it's old now because it's years old, is that workers in these labor markets lose $56 million a week in stolen wages. And that's the reality of low-wage work right now. So when we're really thinking about a future flow program into this labor market, we have to be very conscious about the fact that at the end of the day, we cannot be feeding more and more workers into this exploitative labor market, that we have to at the same time make sure that we're building mechanisms so that workers can enforce their rights. So the subject of discussions with the Chamber has been this issue of future flow. It's what everybody sort of points to as being the sticking point. Senators Graham and Schumer called in President Trumka and Tom Donahue, CEO of the Chamber, to talk about a year and a half ago. There was no hope of a bill at that point, and so they asked us to talk. I said, sure, we'll talk. And we started meeting regularly. There wasn't anything moving at the time, so we weren't really negotiating anything, but really, from the labor standpoint, we put together a team of the different unions we represent, teachers, hotel workers, et cetera, and we have SEIU and UFCW as well at the table, to really sort of try to understand what were the legitimate business interests here. And rather than have a negotiation that was based on outcomes, that discussing caps, 10,000 is too many, is not enough, 100,000 is too many, we really wanted to pull out what interests we could identify. The interests that we brought to the table are that we wanted to have a transparent system so that the problems that Cathleen talked about, that Art talked about, that everyone knows about, that are really exposed, that workers actually have a way to enforce their rights, and that the system in and of itself has some transparency and is based on something real, on labor market data, that labor shortages are what's really driving the program, so that if workers are coming in to fill shortages, nobody disputes that employers should have workers available when they need workers, and just we can't have them under these conditions that Art described. So from that standpoint, we approached the conversation as, okay, these are the interests we need to really promote in this conversation. Business had legitimate interests in having a system that is more flexible, that the static caps don't work, because when the economy fluctuates, everybody's stuck with this cap that exists now, the caps that exist now, and they wanted to have less bureaucracy. So taking those two set of interests as bookends, we've been having a discussion on how do we craft a new kind of a system, a new kind of a program that doesn't replicate the mistakes of the past. So we're not creating a new H2B program, we're not creating a new Bracero program, but we're creating a new approach of how workers come in to our country. We've been advocating the establishment of a bureau, something like the Bureau of Labor Statistics, staffed by experts, professionals who actually will study the labor market, demographers, sociologists, whatever PhD they want to hire is fine with us, but to really bring transparency and credibility to the system. And that we have more access to policies. What kinds of policies public policy should we be implementing right now? Not just in terms of immigration, but also training needs and looking at how labor markets fluctuate. So we've been advocating what we originally called a commission. We were now advocating, as a result of our negotiations, a bureau somewhere in the government. On the business side, they wanted a new temporary worker program, but we agreed early on that we were not going to be able to, they agreed that with the economy the way it is today, unemployment at 16% in construction and other of the industries that we're talking about, they weren't going to get a new temporary worker program. So really to start to think about future flow in a different way. And what we've come up with is a way to fill in some of the details of these bookends of a new kind of visa program. It is not a temporary visa. It is a visa that will give workers the ability to self-petition for green card status. In our view, Chamber and us agreed that it should only be a year. They're Republicans. That's a whole different can of worms. But workers will be able to change jobs among employers in this labor sector that have established a shortage in some ways. So workers will have mobility and the better ability to exercise rights. So if we combine these two concepts, that's the sort of approach that we've agreed to now. We didn't get to the details, in part because of time, but in part because there were just some things that were very hard to negotiate, like wages. So kicked the negotiations up to the Hill, and we've been now working through Senate staff of the Gang of Eight, the 8 senators that are negotiating the bipartisan bill, to fill in those details. They've reached agreement this week on the legalization part of the bill. They have not yet reached agreement on future flow, but we're hopeful and fairly confident that they will. I mean, they have enough of a framework that they have, the sign-off of business and labor, that they would be very surprised if they took a completely different direction from what we've agreed to. There are lots of details yet to be identified, and there are going to be some hard discussions. But generally, we're very hopeful that once we get this out of the way, we can move on to what's really, really, really important, which is really focusing on the path to citizenship. And the labor movement has a multi-million-dollar campaign right now. We kept our infrastructure in place from the Obama campaign and have now moved it entirely to immigration, with a few little actions that we have to do for a fiscal cliff and other sequester and other minor issues. But the structure, our field structure, is there now just for the immigration campaign.
Thank you, Ms. Avendano. Ms. Caron, can you talk more about the need for reform across guest worker programs and the impact slowly changing some programs would have on effectiveness of legislation?
Right. I think when you have these different visas and they're being looked at separately and isolated in an isolated manner, it makes it really complicated, because then we're going to continue reinforcing the system of different rights and different agencies and different methodologies depending on the industry they're coming into, or maybe seasonal versus non-seasonal. There's so much different criteria. So without kind of taking a look at the whole, I think it will, a lot of the same problems will happen, in the sense of employers being able to just shift between different visas and workers having so little sense of what their rights are under that particular visa, because they're so similar. One thing I think is really important that Anna said was that what they're talking about with the chamber, which is the kind of permanent, full-time, non-seasonal, which is like one carve-out, but she talked about a pathway to citizenship. So the core of a temporary guest worker program is that you never stay. You have to go home to your country of origin. And what this means is, if you look at this at the macro level, you're looking at creating a class of workers in a country that has no political voice of their own. Like, they can join a union, and have some sort of representation, but they're never going to vote. They're never going to be citizens. So that kind of is a fundamental shift of a concept of thinking of having people here present. A lot of these visas, they're not allowed to bring their spouses in, so they're coming in as single persons here to work. They're coming in debt, so they're here to work and work really hard. So when you look at the other problems that come out of this, age and gender discrimination, rampant in these programs. And US laws are very difficult to apply overseas. And where does the discrimination happen? In the recruitment overseas. There's been test cases that have not worked on this issue. So literally in Mexico, they'll have a sign that say men over 40 do not apply. Mm-hmm. And this is held up in US courts. So a US worker can't compete against the world. Right? So you take a 19-year-old Guatemalan that's healthy and fit, in debt, shows up to the United States, has a couple of kids at home, maybe he's 22, so he's a couple of kids at home to support, in my little hypothetical. He's going to work so hard, and he's not going to have to go deal with the PTA, he's not going to ask leave from his employer for anything, because he is here to work super hard, and go home and support his family. So just think of that impact that has on just what a worker is in the United States, and he can never vote on top of it. And so US workers are so disadvantaged when you don't have a system that US laws have to apply overseas from start to finish in this. And we have in immigration reform has to be part of it, politically impossible. So the rampant discrimination, and this happens in the Canadian program too. We work in Canada. Literally, Canadian employers say, this is the age, this is the gender, and this is the height. And this is written down. And then the recruiters, which are big international recruiters, reinforce this indiscrimination. It's a really difficult problem, and it's not going to get resolved in this round.
Thank you, Ms. Caron. Mr. Reed, can you talk about how legislative reform will affect those who remain undocumented?
And I got another 3-minute slot, which is also hopeless. Well, I've got to pick for a second up on Kathleen's last point, because I really do think that there is such a correlation between what happens to undocumented workers and what the continued status of temporary worker programs is, that we need to really pay attention to that. The notion of temporary in relation to the H2B program has gotten very distorted over the years. And in the most fundamental, the largest segment of the H2B program, and the industry that we dealt with the most in Pennsylvania was landscaping. Landscaping jobs, if we gave people unemployment insurance in the off-season, are year-round good jobs. If you pay people at a decent rate of pay, there are a lot of poor people in this country who might indeed take jobs if they got unemployment insurance as well. You could turn these into jobs that people could live off of. And when we have a system in which we have people who pay large amounts of visa fees every year to enter into the country, pay large amounts of transportation fees in order to enter into the country, we have a system in which we have people who are really being exploited by this classification as temporary. So I think that one of the things that we need to think about if we're going to leave these existing programs in place, and the Department of Labor has tried. The Department of Labor has tried to reclassify the definition of what's temporary to 6 months, to say no, jobs that could operate a longer period of time aren't temporary. The industry's fighting that tooth and nail. The industry's fighting having to pay real prevailing wages tooth and nail. And the Bush administration consciously drove those wages down. Okay, so undocumented. We will still have, and I think the comments on, yes, we need comprehensive immigration reform that reaches everyone in the country, God help us, let's hope we get that. Even if we do that, because part of what's sending people to the US is our destruction of the economy in Mexico. NAFTA and other things and trade levels have driven people to the US, and it's not just Mexico, have driven people to the US. Because of that, we're going to continue to people who come here. The most fundamental piece, and it is in the piece around from the National Immigration Law Center on the tables, is the expansion of at least retaliatory protections for workers, the whistleblower protections. You've got to make it possible for that worker who the former Utah Attorney General talked about earlier today is exploited by the bad employer to be able to come forward and tell what's happened to them, get some remedy for what's happened to them so that we don't create incentives for that to happen. So that the expansion of whether it's the U, the T, or some other new visa program in order to do that is fundamental. In the meantime, the Palermo is an excellent case. We should be using the administrative discretion that the Immigration Service now has to be giving people temporary legal status with employment authorization where they are the victims of employer retaliation because of concerted protected activity. The NLRB should be exploring getting affirmative roles from the Immigration Service to do that, and that's tough right now, but it's something that needs to be part of what immigration reform is going to be. Time's up.
Thank you, Mr. Reed. Ms. Salas, what enforcement reforms are needed to ensure that these remaining undocumented workers have redress for employment violations?
So one of the things that I didn't get to mention earlier as part of the car wash campaign is that in working in collaboration with the New York State Attorney General's office, when the office investigated some of these car washes, what they found was that they were in violation not only of like minimum wage and overtime wages, but that the employers were also failing to pay unemployment taxes and workers' compensation insurance. So what the employer did, of course, immediately was to change his practices and put everyone on the books, right? Everyone, you know, regardless of whether they had a social security number or any other type of number for tax purposes. What the workers saw then was an immediate decrease in the money that they were taking home, right? So, yeah, a decrease. So if they were earning $400 a week for working really long days, 7 days a week, then all of a sudden they're taking home $250 to $300 a week, and taxes are being taken out, and they don't understand that, you know, how is this? I'm trying to organize, and then what I get is, yes, the employer is now complying with the law, and I am taking home less money, and I cannot survive on this, right? So that's a huge challenge to the campaign. It is a challenge, and it's something that we explain that the employer legally is required to do this. They can deduct the taxes even if you don't have a number, because the agencies will take that money regardless of whether there is a number. So one of the things that we would love to see is that these employee contributions that are already being made into the system, that comprehensive immigration reform takes into account of that, right? And so the workers can benefit from those contributions in the future. One other thing with regards to enforcement, in a perfect world, there probably wouldn't be any more need for ICE workplace enforcement actions, but they will probably continue to exist. And one of the things that I think the agency can do easily to further protection of workers' rights is to, at the time that there's an enforcement action for ICE purposes, that they bring along, or at least have the U.S. Department of Labor investigate the employer for compliance with the labor laws, so that if workers are about to get deported, they at least have, if they're owed any wages, that they go home with them. That is something that sometimes happens already. When I was at the New York State Department of Labor, I know that in upstate New York, oftentimes our investigators would go to the detention center because agents had picked up workers who were working in the country without status and who had not gotten paid for 3 or 4 weeks. And so the investigators will figure out how much money they were owed, go to the employer's workplace, demand the money, and go back to the detention center and have those workers get paid. So it can be done, and it should be done.
Thank you, Ms. Salas. Ms. Avendano, do you have any final thoughts on how to tackle the work that remains after immigration reform?
I think it's really important not to divorce immigration policy from general workplace policy and other important public policies. Focusing on poverty issues is really important. And really sort of combining the advocacy, legal advocacy with on-the-ground advocacy, grassroots advocacy across these different sort of movements, social movements. So we've been doing a lot of work with worker centers around the country, with domestic workers, day laborers in particular, to really take a fresh look at what kind of a system do we need so that workers, whether immigrant or born here, will actually be able to have enforceable rights. And it's really important that we work across sectors and work together.
Thank you. We're going to turn to audience questions now. How do you counsel your clients about the risks, especially if they are undocumented, of going to court or being part of an organizing campaign? And whoever wants to jump in on this one, please feel free.
That's a hard question.
That is a challenge. I mean, we have members that are super active who have developed great leadership skills, and oftentimes we were litigating a couple of car wash cases in federal court, and I remember the organizers telling us that they wanted to speak to a couple of workers because there was going to be an article in the news talking about the campaign, and then the next thing that we see on paper, and we talk to our clients, make sure we prep them, make sure that they're ready to not be too specific about the labor law violations, because we're in court right now. We want them to be very general. The next thing we read is that, and I'm here undocumented, and I don't have papers, and it just makes us cringe a little bit. But our members are very vocal, and sometimes it's really difficult to tell them not to expose themselves. So I don't know, you can prepare people as much as you want, but sometimes it happens.
I'll try and give an answer. We actually, we handle a fairly large volume of undocumented worker cases as advice cases and assessment cases, in addition to as cases that we might litigate or pursue. And part of the process is evaluating and assessing the individual fact pattern for that person of their immigration compliance issues. Are they someone who has been removed on a felony? A previous removal from the country would make your reentry a felony and puts the risk much, much higher than they would be otherwise for that person to be going forward. Do they have a basis for which they can appropriately get a U or T visa, or is it a case in which it's appropriate to be cooperating with law enforcement issues? Are there law enforcement officers that will cooperate with us? What are the risks of state law violations, which in Pennsylvania has been a very serious problem. An issue at the national level is critical, is that we preempt these kind of state law false identity things that treat somebody using a social security number that they have no idea what it is that's fraud, that's identity theft, and prosecuting people, which is happening in Pennsylvania. That kind of stuff has to be preempted. And I think the fundamental answer is that we've got to be able to fight to change the status so that we do get those kind of whistleblower protections I talked about earlier, so that people who come forward with those kind of complaints have the right to get protections to enforce those complaints. Otherwise, we will continue to have a large exploited workforce.
Thank you. Another audience question. Since many immigrants go to a lawyer who specializes in immigration only, what should immigration attorneys be looking for to make sure they don't miss important employment issues?
That's a great question. We usually think about it the other way around.
I mean, there are a lot of them, unfortunately, and part of the problem is driven by, to do a good job of representing somebody in the immigration case, you may want to be blind, deaf, and dumb. I mean, I say that with some seriousness. You may not want to know that your client is working unauthorized when they're not supposed to be. That may impact on your ability to represent the client. So we create a system in which we discourage immigration attorneys being able to holistically assess the situation of their client, and in particular the economic retaliation that they face in relation to their jobs. Again, it's part of why I think the growth and the potentials for use of the U visa and those kind of visas in appropriate circumstances is really very critical, because they give a way for that immigration attorney to be able to give competent immigration advice that is based upon the exploitation of those workers. And I think that that's an important piece of the process, at least understanding the availability of those.
I could just add a little bit to that. If it's deportation defense, they should be asking labor rights questions, because then they're not at risk anymore of coming out of the closet and exposing working unauthorized. But if they're already out the door, strongly ask some basic employment law questions, and then know if the worker goes back and they're deported, the case doesn't stop. Because what we do is we help the worker from the home country be able to demand their rights. And so there's so many missed cases out there of people that are picked up and deported, like, I don't even know, I'm just gonna make millions and millions of dollars lost because someone's not helping that worker get that quick complaint in that they can then recover for stolen wages.
So I just want to add, every single major raid in this country, whether it was a poultry packing plant, the Swift raid, I mean, there's just, you look at every single major raid, you can get a hold of the affidavits that the agents have to file in order to get the search warrants necessary. Every single one of those affidavits shows rampant labor violations that just go unaddressed. So it's a really good question, and I think we should think a lot more about how do we create stronger ties between the immigration bar and the labor bar so that we're understanding each other's issues.
Thank you. I think we'll do one final question about the relation of DHS and Labor Department protecting labor rights. The relation of DHS and the Labor Department protecting labor rights. There's a relationship there.
It's a great question, and it's a very timely question. Going back to what Art alluded to a little bit earlier, in the 90s, actually, this started under Bush 1, but then it was under the Clinton administration, when the SEIU, the Service Employees Union, was just starting the Justice for Janitors campaign that has now sort of become really well known and popularized in the movies even. That campaign was one of the first union campaigns to actually use wage and hour litigation as an organizing strategy. And what the lawyers found, and SEIU lawyers found, that many times as they were trying to enforce wage and hour laws, working with the Department of Labor, that there was a lot of data sharing with what was then INS, and had a really chilling effect on the campaign. So the labor movement started to work with some advocates on a new policy, an internal policy to INS, which was then known as an Internal Operating Instruction 287.3A, that actually put some limits on when and theory, but we used it effectively a lot, of when immigration agents would conduct a raid during the course of a labor dispute. Labor dispute was defined very broadly to encompass wage and hour litigation, everything, every kind of labor dispute you can think of. It really didn't create a substantive right, it was just a process that before a raid could go forward, there had to be, the agents had to get clearance from the director in DC basically. But the practical impact was that when the agency learned that there was a labor dispute, they would think twice about raiding the plant. And I was at the Food and Commercial Workers at that time, and we used that, actually, the operating instruction a lot. That operating instruction sat silent during the Bush administration. Advocates, we didn't want to use it because it's discretionary. We'd rather have it sitting there gathering dust than being pulled. So we were hoping that with President Obama in office that the concept would be sort of revived, that there should be protections for workers so that when they are organizing or trying to enforce any right, they shouldn't have to fear an immigration raid. Unfortunately, we haven't gotten very far with that in terms of labor organizing. The Department of Labor issued a memorandum of understanding that they have with DHS, where for certain complaints, there will be no data sharing, but there's a lot of otherwise protected activity that is left out of that. And so we're still seeing enforcement actions when workers are organizing. And what's even more troubling over the past 5 years has been that we're seeing more and more state-level police enforcement actions on the picket lines, for example, workers being charged with trespass, and then they get caught in the whole system that you heard about now. And with the increase of state laws and state enforcement actions that weren't even covered by the original operating instruction in the first place, there is very little protection in place right now. It's something that we're working on overall the legislation is to codify that concept, at least enough to actually make it a requirement that immigration agents actually respect organizing activity and that there be some sort of firewall between the two agencies.
And again, I think that a future advocacy approach is to say that the firewall hasn't been enough and that instead we need the Immigration Service to be prepared to use the discretionary relief that's been exercised in the DACA context to say affirmatively, okay, we recognize that these are people with a labor dispute. We are going to give them employment authorization and allow them to assert their rights, and we are going to recognize that doing any immigration enforcement interferes with the right of all workers. So I think that potential exists within the existing law, with the existing discretion, but it requires not we don't talk to each other, but it requires a very different approach, and it requires Department of Homeland Security to accept that they have a responsibility to act that way. I will say that we have explored this in some individual cases where we have workers who have complaints about things that also constitute criminal violations by employers of other statutes. And there are some possibilities there, but it has to be a much more broader scale kind of change of policy if we're going to really protect workers' rights. We have to affirmatively say, okay, if you workers are organizing, you should have protections. And the reason why I said a theory is we had a case in Pennsylvania where we used the operating instruction in a mushroom worker organizing case under Pennsylvania law, Pennsylvania Labor Relations Act. There was a union election in dispute, and we've served notice of the labor dispute at that company, and the Immigration Service came in and conducted a raid and deported all of the people that were members of that union, most of whom were back at work, by the way, a few weeks later, but they were back at work under circumstances where they could no longer dare come forward again in terms of stuff.
I want to add one thing. The Obama administration has issued a prosecutorial discretion memo, and that requires so that agents actually look at whether there's some sort of civil rights enforcement or whether workers are trying to vindicate their rights and deciding whether or not to put someone in removal proceedings or to close a case. And that's a good first step, but it's not enough. So because that's looking at the situation from an individual relief standpoint. What we need is collective relief. We need the operating instruction provides workers collective relief, workers in a particular situation, a particular class, need to have that protection. The DACA is a great example of collective relief, and like Art said, there's no actual legal reason why the administration can't start thinking along those lines. And in fact, we, in case immigration reform does not happen this year, there is a pretty robust administrative agenda that advocates are developing to address questions along on that framework.
Thank you. If everyone could join me in thanking our panelists today.